The information presented today is not intended to and does not constitute legal advice, recommendations, or counseling under any circumstance. You should not act or rely on any information provided without seeking the advice of an attorney licensed to practice in your jurisdiction for your particular situation. In addition, the information presented does not necessarily reflect the opinions of our clients. So now it's my great pleasure to introduce today's presenters, Ian Wagrish and Mary Jo Courageous Reynolds. Ian is a partner with Hinshaw and Culbertson and handles business-related immigration law for multinational corporations, hospitals, nonprofit arts institutions, universities, athletic organizations, and individual investors and entrepreneurs. A passionate advocate for more just and humane immigration system, Ian is committed to helping his clients navigate each step of an increasingly complex process. In addition to providing counsel on non-immigrant working visas, employment-based permanent residence, and labor certification, Ian has advised clients on investment-related immigration and employer sanctions. Ian has effectively assisted a wide variety of clients in meeting their business immigration needs. This includes managing the paperwork required for hiring highly skilled workers, advising on the international transfer of personnel, leading corporate compliance initiatives, and assisting employees with obtaining U.S. permanent residence and citizenship. Recognized as a leading voice in the area of immigration law nationwide, Ian frequently speaks on immigration issues at universities and continuing legal education seminars. He has also appeared in print media and television news programs, including CBS Morning News. Mary Jo Courageous Reynolds is an associate with Hinshaw and Culbertson and defends the interests of employers in a range of labor and employment matters. Committed to working hand in hand with employers, Mary Jo helps businesses of all sizes navigate the ever-changing legal landscape in order to limit their liability and exposure. In addition to helping employers ensure they are complying with statutory and administrative regulations, Mary Jo has experience representing employers in immigration matters, including the filing of employer-sponsored visa petitions and in I-9 audits. And now I'm going to turn the presentation over to Ian. Thank you.
Great, thank you. It's great to be here speaking at the L&E seminar. We're really excited. This is the employment-related immigration is an area where we're really, as a firm, making the deep dive and growing the practice. In addition to myself and Mary Jo, we have Carlo Reyes in Chicago with some expertise in this area. We have a new associate, Ritika Narayanan, who Ritika has a really strong background dealing with deportation defense and removal matters. So if any of your employees have any issues that come up in that regard, we can help. And then at the end of the year, we should be expanding, have some new additions, expanding our knowledge base even further. So this is really going to be a real strength of the firm. Instead of reviewing everything we're going to go over, I'm going to jump right in. Those of us dealing with employment related to immigration these days, we're sort of living in a world of presidential proclamations and executive orders. And this has really affected how we work on a day-to-day basis. And it's everything has gotten more difficult and more involved, and it really helps to have a practice with sophisticated knowledge and experience in this area to deal with these proclamations. So what are the proclamations? The first one, March 11th, suspended the entry of individuals to the US of people who have been in the Schengen area, the UK, Ireland, China, and Brazil with the immediate 14 days prior to arriving in the US. It applies to immigrants and non-immigrants. So immigrants refers to green card holders, US permanent residents. Non-immigrants, individuals on a temporary status like H-1Bs, intercompany transferees, E-1 or E-2 treaty investors. Now, one exception to this Schengen area ban is students in F&M status can still travel, don't need to obtain, and can obtain visa stamps if their embassy is open. So a lot of what we're going to talk about, if people don't have visa stamps, they may in theory, be able to get a national interest exemption, but their embassy might not be open. So as a practical matter, it still might be impossible to travel to the US. Business travelers can still travel with a valid visa or ESTA, but need to get a national interest exemption in order to travel. And we'll speak a little bit more about the national interest exemptions later. So that's the first proclamation, the Schengen Area Proclamation. The second proclamation, about a month later, refers to immigrants, so US permanent residents. Suspends the entry of an individual who was outside the US as of the effective date of the proclamation, does not have a valid immigrant visa, and doesn't have a valid travel document. So, if somebody was inside the US as of the date of the proclamation, it doesn't apply. If they do have a valid immigrant visa, it doesn't apply. If they have a valid document, like an advanced parole travel authorization, it doesn't apply. So the third proclamation, so we have the Schengen Area one, the Immigrant Proclamation, and now the Non-Immigrant Proclamation. Oh, forgot some areas that are exempted. I spoke already, lawful permanent residents are exempted. EB-5 investors, that's interesting, they're exempted. And individuals who would be in the national interest. Again, I'll talk about national interest exemptions in a little bit. So the next proclamation applies to non-immigrants. Suspends entry who's seeking to enter pursuant to an H-1B visa, H-2B visa, J visa, L visa. Exemptions, lawful permanent residents, so individual on a green card, spouses or children of US citizens, individuals seeking to enter, provide temporary labor essential to the food supply chain, and individuals whose entry would be deemed to be in the national interest. Again, there's that national interest exemption. Now, I'll note, before we get to that code announcement, I'll note there's a recent lawsuit. So October 1st, a federal district court, and this is in the National Association of Manufacturers versus Department of Homeland Security. They enjoined the government from enforcing this particular presidential proclamation against named plaintiffs and members of the plaintiff association. So who are the named plaintiffs? The National Association of Manufacturers, the US Chamber of Commerce, the National Retail Federation, TechNet, and Intrax Inc. So any J1, H1B, H2B, or L1 applicant who's sponsored or entering as a J1 exchange visitor for one of those organizations is exempt and no longer subject to the entry restrictions. So what if you're a company who's not a member of the Association of Manufacturers and the US Chamber of Commerce? Well, go ahead and join those organizations. I know Chamber of Commerce, I think the entry fee is like $250. If you have an essential employee, maybe worth the $250 fee in order to get one of your H-1B employees or one of your L1 intercompany transfers into the US. Posts have been closed, are gradually reopening. However, the posts that are reopening have been instructed that H, L, and J visa applicants who are being employed by companies that are part of the plaintiffs in this lawsuit can request emergency appointments to get their H, L, or J visa stamp. So, reach out to the embassy, request an emergency appointment. The embassies have the instructions for requesting appointments on their website. So it is possible for employees of those individuals to get visa stamps even without applying for a national interest exemption. Sort of a big theme of this past year in the employment-related immigration has been, the administration closing the door on something and the federal courts opening the door again. And I'll talk a little bit more about another context where that may be happening in a little bit. So this is one of those areas where the federal courts have jumped in. The administration has used the COVID-19, the coronavirus pandemic, as a way to try to shut down immigration completely, and the courts have pushed back on that a bit. Now I'll give you the first CLE code, which I had written down somewhere. It is WP. The first code is WP. Okay, we talked about a little bit about these proclamations barring entry. Now, what's a national interest exemption? You know, even if you're subject to a proclamation, you may be able to apply for a national interest exemption to re-enter the U.S. So for L1A applicants, those are intercompany transferees, you can get exemption if you're a healthcare professional treating or performing research on COVID-19. And in my experience, the embassies have been interpreting this exemption pretty broadly. And they've been quite willing to grant these exemptions. Travel supported by requests from US government agencies. Travel by applicants seeking to resume employment in the US in the same position with the same employer. So they're not subject to the non-immigrant proclamation. They still need a valid visa stamp to reopen. They still need to apply for the national interest exemption. So even if they have a valid visa stamp, they still need to get a national interest exemption to re-enter the US and travel by senior level executives filling a critical business need. Again, it looks like the embassies, it varies embassy by embassy, but it looks like the embassies are interpreting this pretty broadly. L1Bs. So L1Bs, individuals with specialized knowledge, intercompany transfers with specialized knowledge. So the exemptions apply to healthcare professionals treating or performing research in COVID, travel supported by request from US government agency, travel by applicants seeking to resume ongoing employment. So, you know, if somebody's resuming the job that they were working on before departing the US, and travel as a technical expert or specialist meeting a critical infrastructure need. Again, it looks like the embassies are interpreting this last prong pretty broadly. So you still, I mean, even if they have a valid visa stamp, they still need a national interest exemption in order to enter the US. But the embassies are being pretty flexible. The national interest exemption, so I'll talk a little bit about the mechanics. So you have a valid visa stamp, you can't enter the US because of the travel proclamation. What you do is each embassy will have instructions on their website for applying for a national interest exemption. Typically what you'll do is you'll email a special email box. They'll email back with a list of documents that you need to submit. So then you'll submit those documents, and within about 5 days, you should, depending on the embassy, it varies by embassy, you should have a response on the request for the national interest exemption. The national interest exemptions are typically being issued for 30, they're valid for 30 days is what I'm seeing a lot of. So if the individual enters the US, works for 6 months, if the proclamations are still in place, they leave, they'll need to get a new national interest exemption in order to re-enter the US for the most part. It's not universal. Some more fun things dropped on us by the administration recently. There's new Department of Labor and DHS regulations relating to H-1Bs. These DOL regulations significantly raise the prevailing wages. So these are the wages that will need to be paid to H-1B employees, to individuals going through the permanent residence process. And the interesting thing about this is they were dropped with no notice at all. No notice and comment rulemaking, emergency rulemaking, immediate effect. Again, here's another area where the courts are pushing back. Well, we're hoping the courts push back. Sorry, I got ahead of myself a little bit. I have a sense that they will. Now, as part of the rationale for having no notice and comment rulemaking and dropping this regulation with immediate effect, the Department of Labor said, well, if employers know that these wages are going to go up, if we have notice and comment rulemaking, then they're going to file a lot of labor condition applications for H-1Bs before the rules take effect. And so, you know, we can't give them notice of these new regulations, you know, otherwise that'll happen. Well, the interesting thing was a couple months before implementing the regulations without going through notice and comment rulemaking, they had a public press conference announcing that they were going to have these new rules. So the cited rationale for skipping the usual notice and comment rulemaking falls apart when they're having public press conferences to raise the rules. Now, if they had notice and comment rulemaking, the significant flaws in their rationale and their methodology for determining the wages would have been discovered. If any of you know, and stakeholders could have commented and they could have fixed the problems with their surveys and issued the rules in a proper manner. So I suspect that through, there's several lawsuits pending on this right now. I suspect that these are going to get overturned and have to, if they want to implement these rules, they'll have to go through notice and comment rulemaking. I don't know if any of you have heard, there's an election coming up shortly. It's possible that there be a new administration in January. I don't think there will be time to get this particular rule implemented through notice and comment rulemaking before there's a new administration. I know that this particular rule is not a priority of a potential Biden administration. So we'll see what happens with this. I'll note, if any of you are healthcare providers out there, you know, for a lot of occupations in these new rules, under the new calculations, for a lot of occupations, the Department of Labor is defaulting to a $208,000 prevailing wage in areas where they don't have enough data to make up. So say you're a medical facility in, you know, Peoria, Illinois. Can you pay, you know, and you have a doctor who just, you know, in their fellowship on an H-1B, you go to renew the H-1B, under these regulations, you'd have to pay them $208,000. Does this make sense, you know, when there's a shortage of medical care providers in the middle of a pandemic? Probably not. So, you know, I think for a lot of reasons, this particular regulation is going to get overturned. Now, there's new DHS regulations that significantly narrow the definition of specialty occupation in the H-1B context. It sets a maximum validity period of approvals for H-1Bs placed at third-party work sites. It requires petitioners to show that work is available as of the requested start date and throughout the validity of the petition. These rules actually have notice and comment period, so they'll become effective December. Several organizations have sued on this rule, including the American Immigration Lawyers Association and the Chamber of Commerce and a group of universities, including Purdue University. This rule, there was recently a settlement, you know, you know, in the area of third-party work sites, where the Immigration Service agreed that they wouldn't set a maximum validity period for approvals of H-1B, that they would no longer request that petitioners show work is available for the entire 3-year requested validity period. So this particular rule goes completely contrary to the settlement in that it's called IT-Serve, in that IT-Serve case. So I suspect this rule will not survive litigation either. So next year when we do this, we can see if my gazing into the crystal ball was correct or not, and if these two sets of regulations were both overturned by the federal courts. Another fun new area that we delved into in this past year was electronic registration for H-1B petitioners. So it was in effect for this current, in April. Well, what happens is in the old process, we used to file H-1B petitions all, in the first week of April, hoping to get in selected in a lottery. The USCIS had a lottery for the limited number of H-1B petitions that are effective at the start of the next fiscal year, October 1st. So there's 65,000 H-1Bs available, plus another 20,000 for individuals with master's degrees from US universities. And they would typically get about 200,000 applications. So you would prepare a filing, send it in, and hope it gets selected. If it wasn't selected, then the Immigration Service would pack up the 120,000 petitions that were not selected and send them back to the petitioners. So really effective use of government funds to send back all these petitions that were not selected. So they decided to have an electronic registration for the lottery, which makes sense. Register ahead of time, pay a $10 registration fee, and then if you're selected in this registration, then you had 90 days to file the petition. This year, it was interesting because, the economy tanked, the employers did not, they had made a hiring decision earlier. They no longer wanted to hire the individuals and sponsor them for H-1B status, a few months later, once April or May hit. So a lot of employers ended up not filing the petitions, notified the Immigration Service they wouldn't use them. So they ended up having a second lottery of those registrations, selecting another batch of petitioners because the numbers were down for those reasons. Now, right now, I am dealing with this particular issue, immigrant petition reclassifications. Now, if any of you hire Indian nationals who you're sponsoring for their permanent resident, you're probably getting asked a lot of questions about this. Now, what does this have to do with? Usually, the waiting period for Indian nationals who are in jobs that require at least a bachelor's degree, it's a much longer waiting period for jobs that require at least a bachelor's degree than for jobs that require a master's degree or a bachelor's plus 5 years of progressively responsible experience. So in the October visa bulletin, that got flipped. So the EB3 waiting periods, those are the jobs requiring a bachelor's degree, became less than the EB2 jobs requiring a master's degree. So any number of individuals who were classified as EB2 suddenly wanted to be classified as EB3. So the way that works is we actually file a new I-140, a new immigrant petition on behalf of the individual requesting the new classification. And in a way, this doesn't invalidate the previous I-140, the previous immigrant petition. This gives the individual more options. If any of you are currently employing Indian nationals, you may be hearing a lot of anxiety about the November visa bulletin. The visa bulletin is typically issued on the 15th of the month preceding the date. So the October visa bulletin was issued September 15th. So that gave us an idea of whose whose adjustment of status, that's the third step, whose green card applications we could file. Now, the November visa bulletin, typically it would have come out about October 15th. And here it is. We're at the end of October and it hasn't been released yet. Well, why? What is going on? Well, I'm hearing through some contacts within the Department of State that what's going on is that the dates for November should remain about the same as October. Those individuals who were able to reclassify their immigrant petitions in October should still be able to file in November. We're not 100% sure because the visa bulletin hasn't come out yet. And what's holding it up is that Hong Kong, the Department of State is reclassifying Hong Kong as part of the People's Republic of China. Now, typically, usually Hong Kong has its own independent, was considered separate. And the waiting period, if you were born in Hong Kong, to be able to complete your permanent residence process was much quicker, and there are backlogs for individuals from People's Republic of China. Well, with this reclassification, individuals from Hong Kong are going to get stuck in the same backlogs individuals from People's Republic of China. There's some behind the scenes wrangling going on about this. It'll be interesting to see when the November visa bulletin comes out, whether or not individuals from Hong Kong have their own classification or if they're classified with people from People's Republic of China. So it'll be interesting to read the fine print of that November visa bulletin. Another hot area, if you're a university, this is causing extreme headaches. So what does that mean, DS? Typically, an individual who's a student or an exchange visitor, a J1 exchange visitor, is admitted for how long it takes them to complete their program. So, that DS stands for duration of status. So sometimes it might take a student 5 years to complete a program. Sometimes they might complete it in 3.5. So it gives some flexibility for the individuals who are entering to complete the program. Now, under the new regulations, students will be given a definite expiration date of their period of stay. So it'll be given 2 or 4 year period of authorized stay, depending on the type of program, depending on some other factors that are beyond the individual's control, whether or not they're from a country that tends to have a high rate of overstay in their students. So another thing is students and exchange visitors will be required to apply for an extension of stay from within the US instead of just being able to stay for the entire period of authorized stay. They'll have to provide biometrics when applying for extension of stay. Now, these extensions can take an incredibly long period of time. 6 to 19 months, I think, is the official processing times right now. And another really harsh consequence of these new rules are F&J students who would be subject to the unlawful presence rules currently in effect for other visa classifications. There could be some pretty draconian consequences of being subject to the unlawful presence rules. And this, again, will be the subject of litigation, I'm quite certain. And for physicians who are completing their medical training in J1 status, an increasing level of uncertainty. There's, I don't know the exact numbers, maybe 10 to 12,000 J1 exchange visitors approved each year to provide medical services, often in underserved communities. A lot of them, their spouses in J2 status get employment authorization. A lot of their spouses are also physicians. When the spouses file for an extension of their employment authorization, when they're current, they don't get an automatic extension of their employment authorization. So they could have to go off the payroll while the application is pending. Again, I mentioned it could be 6 to 19 months. So this could have some really draconian effects. I think it basically may take international medical graduates out of the J1 business. It could really affect the provision of medical services by J1s in this country at a time where there's a critical shortage and we're in the middle of a pandemic. So we'll see if the final regulations will have the same effect, and whether they respond to the comments or not. We'll see if the final rule looks a lot like the current rule. I expect more litigation in that regard. Premium processing fees. The continuing resolution to keep the government funded had a little sneaky provision in there that some of it was positive and some was negative. First of all, it increased the premium processing fee to $2,500 for most classifications, except for H-2Bs, which are temporary non-agricultural workers, and R1 religious workers. Those only increased to $1,500. Now, in the piece of legislation, it also gave the Immigration Service the power to increase the types of petitions that would be subject, that permitted to file using premium processing. So multinational managers, green cards for multinational managers were one of the permitted classifications. Requests for national interest waivers, so for researchers or people doing work that advances critical national interests, would be, the Immigration Service was permitted to add those to those which you could file using premium processing. Well, the Immigration Service, sort of did part of what they're allowed to do under this legislation. They immediately, with no notice, raised the fees, but they didn't expand the classifications at all. So the classifications that you could file for premium processing are the same as they were before. So, not a lot of non-immigrant petitions, H's and L's, you could file using premium processing, but no multinational manager, immigrant petitions, no national interest waivers. So a little sneaky. They have more time, so hopefully sometime in the near future, those other classifications will be added. And with that, do we want to jump into Mary Jo talking about I-9s and compliance?
Sure. Thank you very much for that overview, Ian. Good afternoon, everyone. Thanks for your time and attendance today. I am going to speak to compliance issues, which are relevant for all employers, regardless of size, and regardless of whether you as an employer sponsor a non-immigrant for a visa. So as you likely know, Form I-9 is a mandatory obligation for any employee hired after November 6, 1986. And the reason that employees have to complete Form I-9 is in order to comply with the Immigration and Nationality Act, which requires employers to not knowingly hire or retain unauthorized workers. And again, this federal statute applies to all employers regardless of size. So you as an employer have an affirmative obligation not to knowingly hire or retain workers who aren't authorized to work in the US, and part of that obligation encompasses use of the Form I-9. Friendly reminder, if you're using an old form that you've had in your archives for a while, check USCIS's website because there's been a couple updates to the form in more recent years. Recognize that if you fail to complete Form I-9 and to complete it properly, you may be subject to monetary fines. And in fiscal year 2019, employers were ordered to pay over $14 million in such fines, forfeitures, and other restitutions. So the financial consequences of failing to comply with Form I-9 obligations under federal law are not insignificant. We are seeing a significant increase in the number of random I-9s conducted by the federal government. And since 2017 in particular, there's been an increase. Last fiscal year, there were 6,456 audits, and that compares to just over 1,000 in fiscal year 2017. I suspect that there will be a high number of audits into the coming fiscal years. There may even be an increase because obviously the federal government needs money, and the we have found that the audit process is a revenue generating option for the government. So these audits are conducted by ICE, the Immigration and Customs Enforcement Bureau of the Department of Homeland Security, and they would be something that an employer could be subject to at random. You get a notice and then you have a short window of time to gather your paperwork and to comply with the requests of ICE. Next slide, please, Ian. The second CLE code announcement is the numbers 28 as in today's date, October 28th. So again, the code so far is WP28. So let's do a deeper dive into the components of Form I-9. I know many of you are very familiar with this if you work in HR, but there are some nuances to the various sections that I just want to highlight, particularly regarding timing. So Section 1 is completed by the employee, and it has to be done on or before the employee's first day of work. And sometimes if you are expecting the employee to do this on his or her first day, it can get lost in the shuffle and the excitement of a new hire and all the other administrative process. And so, you know, it's sometimes a best practice to try and have the employee complete Form I-9 in advance of his or her first day. And if you're having them completed on the first day, make sure that you're sending them friendly reminders to bring certain documents with them. Make sure that they are checking the applicable box that's contained within Section 1 of Form I-9, indicating whether they're a citizen, whether they're a non-citizen national, lawful permanent resident, etc. If they have certain expiration dates connected to their status, make sure that they're filling in those dates. You know, what we often see and what can sometimes constitute a material substantive error is kind of a cursory completion of this Section 1. You don't want to leave things unchecked. You know, if it's not applicable, feel free to write an NA, but don't just leave things blank and presume that that's acceptable. In terms of Section 2, this is the section that's completed by the employer. And this requires the employee to present documents of his or her choice. An employer cannot say, I want to see your permanent resident card, or I want to see your passport, or I want to see your driver's license and your social security card. An employer has to allow the employee to choose what to present. You can give them guidance by providing them with a list of acceptable documents, but ultimately what documents are presented is the employee's choice. And then when the employee presents those documents, the employer has an obligation to review them. And you need to make sure that you're looking at one of two things. You want the employee to present either a List A document, which often is an EAD or a passport or a permanent resident card, or you want them to present a List B and a List C document. So if they present a List A document, they only have to present one thing. If they present a List B or a List C document, they have to present two things. Often we see a driver's license and a birth certificate, or a driver's license and a social security card. A note about social security cards, you want to be a little cautious to make sure that the security card does not contain a notation that may limit their work authorization. There's some nuances to the acceptability of social security cards. So if you see a social security card that has any additional notation, that could be a red flag, and you may want to do a deeper dive to confirm that that is in fact an acceptable List C document. When these documents are presented by the employee, it's best practice to make a copy of them and to be cautious not to make too many copies of unnecessary documents. So if you have an employee who comes to you and says, here's my driver's license, my social security card, and my passport, before you take all three of those documents into your possession to examine them, tell the employee, wait, you only need to present your passport or your driver's license and social security card. Let the employee decide what they want to present. Don't make copies of all three, only make copies of what is necessary to attest to their work authorization and their identity. But maintaining those copies of documents is very helpful in the unfortunate event of an audit to retrace what's occurred and to do an internal audit or an external audit for that matter to ensure compliance with I-9's requirements. As with Section 1, timing in connection with the employer completion of Section 2 is critical. Section 2 needs to be completed within 3 business days of employee's start date. And it can be done in advance, but it has to be done no later than those 3 business days. And really, practically speaking, that doesn't give an employer a lot of time. So when you're onboarding employees, I-9 needs to be top of mind to ensure that it's completed accurately and thoroughly, and to be sure that it's completed timely. Some of you on this presentation may be registered to use E-Verify, which is a very helpful compliance tool offered by the federal government. That is a step in addition to completion of Section 2. It's not a substitute to completion of Section 2. And if you are registered to use E-Verify, my recommendation is that you just print out the checkmark receipt verification and attach that to the I-9 along with the copies of the documents that were presented to you by the employee. When you are looking at the documents presented by the employee, make sure that the same person who is looking at those documents is the one signing the attestation in Section 2. You don't want one employee looking at the documents and another employee signing saying the documents were looked at and they look to be authentic. You want that individual to be the same person. And in terms of Section 2, as with Section 1, make sure that it's being filled out completely. There's, information that's often overlooked, particularly basic information about the employer, but in an effort to be compliant with the requirements, make sure that you fill all of those blanks and those boxes out. I talked about attestation, but just to be clear, understand that when you're reviewing these documents, there is no obligation for you as the employer's representative to independently verify this person's identity or independently verify the individual's work authorization. Rather, you simply need to look at the documents, and when you sign the line on Section 2, you are attesting to the fact that the documents appear to be genuine and that based on what you're seeing, the individual appears to be authorized to work. So that is the threshold expectation in terms of the attestation in Section 2. Moving into Section 3, this is a section that is not going to be required for every employee. In fact, depending on the nature of your workforce, it may not be required for most employees, but I find that it's the section that is most often overlooked. So while you may not need to fill this section out for U.S. citizens or for most lawful permanent residents, and you don't need to do anything with this section regarding List B documents, which confirm identity, you may have to do something about this in connection with List A or List C documents as they pertain to work authorization. This section needs to re-verify an individual's work authorization status if that status is tied to an expiration date. And there's a link between what's completed in those boxes in Section 1 and whether that should be a red flag that you as the employer need to re-verify their employment in Section 3. My best practice recommendation is that you establish a calendaring system that has reminders so you can track expiration dates and give advance notice to employees. Based on Ian's comments, as you can readily tell and as you've likely experienced, some of these renewal processes take months, if not longer. And so it's very helpful for you as the employer and for your employee if you're checking in well in advance saying this expiration date is going to arrive in 9 months. We just want to bring this to your attention. At that time, we're going to re-verify. Make sure that you're proactively addressing the re-verification requirement that's in Section 3 of Form I-9.
Yeah, and I'll note that certain classifications allow for an automatic extension of employment authorization when the individual files for extension, and certain do not. So if you have any uncertainty in that regard, definitely reach out to one of us and we can help clarify for you.
Very true. So what our recommendation is as a best practice is that you conduct an internal I-9 audit. And, you can start small. You can take the last 3 months of hires and look them over and cross-check the documents presented versus the information entered into Section 2 and make sure that you are in compliance. This is also something, if you wanted to retain our firm, we would be happy to help you with. And when, in our experience, we've conducted these audits or we've participated in ICE audits, we find certain errors are most common. We find that, sometimes it's a simple Scrivener's error. Often there's errors related to document numbers. For example, Ian, if you want to go backwards one slide, often there's a mistake as to what an EAD or a permanent resident card document number may be. People inadvertently think that it's the USCIS number, which you see circled there in blue on the sample permanent resident card. That in fact is not the document number, and instead the document number is a 13-digit code that usually begins with 3 letters that is on the back of the card. That may constitute a substantive error, and that's a simple thing, that you can proactively fix if you recognize that error. We, as I mentioned, often see failures to re-verify, and we often see timing issues. Not so much in terms of Section 1 being completed by the employee's first day, but very frequently in terms of Section 2 being completed within those 3 business days. I think, sometimes it's difficult if there's a weekend in there. The weekend may or may not count depending on the nature of your workforce. Often it doesn't, but understand that the timing requirements are strict obligations. Next slide, please. So I mentioned that it's a best practice to conduct an internal audit. And if you are interested in pursuing this, we do have a pretty robust checklist that we would be happy to send your way. So feel free to reach out to either Ian or myself or any of your other attorney contacts within Hinshaw and Culbertson, and we'd be happy to point you in the right direction and get you started with this checklist. If you conduct an internal audit and you find Section 2 errors, you can correct them. When you do so, you don't want to white anything out. Rather, you want to leave an audit trail. So you'd want to cross a mistake out and then initial and date next to it, and then correct it as appropriate. And doing this can help you catch errors. And then if ICE audits you, this will help you avoid penalties. So there can be a real return in terms of time and investment spent in connection with an internal audit. I want to point out the link at the bottom of this slide. This is a link to the M274, which is a handbook that's available by USCIS. And this is an excellent, often overlooked resource. This is a resource that I consult routinely when I get questions about I-9. To Ian's point, this is a resource that can show you when there might be an automatic extension of work authorization. It's a resource that can show you when a receipt may be acceptable. And it's a resource that can help you both navigate rather reoccurring I-9 questions as well as unique I-9 questions. So I urge you to, in all your spare time, pull up this website and begin to learn what a great and valuable resource that can be for you.
And then a couple other notes on I-9. We've been offering sort of a prophylactic I-9 audit. We're a lot friendlier with our I-9 audits and generally much less costly than ICE. So sometimes that could be helpful just so you can get an idea whether there's a pattern of problems or not. And we could also come in and train the people who are doing the verification process internally and help train your human resources people and make sure that's going smoothly. And Mary Jo, I do have a question for you. I noticed there's a new I-9 form. Do we need to use that new form for all employees or only for new employees?
Only for new employees.
Excellent. That's helpful.
Yeah, you don't. Yes, good point. You don't have to go back and use new forms for older employees. Once the form's released, then it's effective for new employees. Couple other random I-9 observations. One, make sure that you are recognizing the retention requirements. I-9s need to be maintained for 3 years or 1 year following termination of employment, whichever is longer. Also, if you're looking to maintain your I-9s electronically, be careful doing so because there are some strict requirements as to document retention. Make sure that you are keeping I-9s in separate files, separate and apart from the personnel files. That will help you if there's an audit, and be cognizant of those retention expectations. Also, if you've joined us for the other presentations the last couple of days, you likely heard some updates regarding joint employer issues. And just be cognizant that joint employer could spill over into the I-9 arena. So if you are closely tied to another employer representative, make sure that you have an understanding of their I-9 practices and that they're in compliance, because you won't want to be found liable for their violations of the I-9 requirements.
Yeah, that's a little scary, the way the this concept of joint employer is getting expanded, and we could be seeing that in all sorts of other contexts.
It is. So there have been some COVID-related updates in connection with Form I-9, and ICE has recognized that a lot of employees are not going into a physical workplace right now. And so they've kind of made things a little more flexible for the time being, but there's a catch on the back end. So if you are in a situation where employees are not going to go into a workplace on their first day of work, it's permissible for you to inspect their documents electronically and do this remote inspection and attestation. If you do that, you are instructed to enter COVID-19 into the additional information fields available in Section 2. But the catch on the back end is, once the world goes back to normal, whenever that is, hopefully sooner rather than later, and you have the expectation that employees go into work, then the employer needs to physically examine the documents a second time and is instructed to do so within 3 business days of reopening. And so that's a really tight time window. And I suspect that for a lot of employers who are, going to be restarting in whatever the new normal is, re-verifying Form I-9 is not going to be top of mind. But technically, in order to be in compliance, it should be. So be aware, if you're doing remote review and attestation, that there is an expectation that 3 business days after reopening, then you're supposed to physically review the documents presented a second time. There are some nuances as to what happens if they're expired or things like that, but we won't get into that minutia. Suffice to say that you have to re-verify them, and that ICE has given directives as to how that process will work. ICE has also said that certain receipts, particularly in the context of EAD renewals, may be acceptable for the time being. It's also extended the time frame in which to resolve E-Verify tentative non-confirmations. So given the COVID circumstances, there's a little flexibility. There's also some updates regarding posting. Now, to get a labor certificate, you have to post, and if you're filing for a new LCA, the Department of Labor is recommending that you post electronically, and you can do this using any mode ordinarily used to communicate with your employees about job vacancies, promotions, and these would include things such as using your website, using an electronic newsletter, the intranet, or an email. If you email your employees and they're notified directly, you only have to do this once. You don't have to do it for 10 calendar days, but otherwise the underlying requirement is that the notice be posted for 10 calendar days. There's also nuances to this posting requirement, but just understand that if you have a new LCA that you're filing with the Department of Labor, make sure that you're still adhering to the posting requirements. And right now, given our work environment, the easiest way to do this is through electronic notification. If you have current employees who are subject to an LCA, recognize that you need to think about whether a new LCA needs to be filed if they're changing work sites. If they're changing work sites to a new job location in the same area as their otherwise intended employment, it is unlikely they need to file that you need to file a new LCA on their behalf. But if you're otherwise changing their work site and they're going outside of that intended area, in certain visa categories, you may need to file a new LCA. And again, there's the notice requirement for 10 calendar days, and likely the easiest way to satisfy it is through electronic notification. But understand that the DOL expects notice to be adhered to, but is going to be flexible and will consider notice timely if it is as soon as practicable and no later than 30 calendar days after the worker begins work at the new location. But I think the cleanest thing to do is just to do it electronically and try and do it on the front end before the worker is moved for those 10 calendar days.
Okay, and someone asked what the LCA is. That's the labor condition application for the H-1B.
And thank you. Yes, good question. And last but not least, in a time of the pandemic, we've been getting a lot of questions about, unfortunately, we're having to make difficult decisions regarding layoffs and furloughs. How does this work if we are sponsoring non-immigrant employees? And a word of caution on this, it's not impossible, but you do need to be careful when furloughing or laying off or otherwise changing the terms and employment of a sponsored employee's employment with you. And there may be some notification requirements, and you may have submitted something, for example, the labor condition application saying, we're going to pay a certain wage, we're going to have them work a certain number of hours, and falling below those numbers may result in non-compliance. There might be some flexibility to move people into non-productive status, or otherwise, finagle things where it's doable, but don't just assume that any employees you have who are sponsored by you on a work visa can be treated the same as your other employees. If you're making those employment decisions, make sure you pause to think through the potential consequences.
Yeah, you should definitely reach out to us if you have any questions in that regard. Absolutely. And then a couple of the questions that came in, there was a good question about NAFTA, whether the visas are still available under NAFTA after the trade agreement was renegotiated. And yes, definitely still available. The immigration portions of that agreement, of that trade agreement, have not changed. So that's proceeding as normally. There were some good questions about in what context you might want to keep copies of the documents provided with an I-9 or not. And there's pros and cons to each situation. So if you want to, discover, go over some of the nuances, you could get in touch with either one of us and we could talk about some of the pros and cons about that. We do have, looks like we're up to our hour. So we do have our, remember the advice on tap on Friday. Any questions that we couldn't get to, we will cover advice on tap. And any additional questions that you might have, and we'll do some additional gazing, into the crystal ball at the year ahead in immigration.
Yeah, well, I do see that a lot of questions regarding I-9 audits have come in, and we will make sure that those get covered at Advice on Tap. Thanks for your time and attention today. With that, we'll turn it over to Cheryl.